Hello everyone. Now we have reached to Article 22, which states that protection against arrest and detention in certain cases. Clause 1. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Subclause 2. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. Clause 3. Nothing in clauses 1 and 2 shall apply. A. To any person who for the time being is an enemy alien, or B. To any person who is arrested or detained under any law providing for preventive detention. Fourth, Clause 4. No law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless A. An advisory board consisting of persons who are or have been or are qualified to be appointed as judges of a high court has reported before the expiration of the said period of 3 months that there is, in its opinion, sufficient cause for such detention, which you can see here, and provided that nothing in the subclause shall authorize the detention of any person beyond the maximum period described by any law made by Parliament under subclause B of clause 7. Um, Clause 5. When any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. And subclause clause 6. Nothing in clause 5 shall require the authority making any such order as is required to in that clause to disclose facts which such authority considers to be against the public interest to disclose. Clause 7. Parliament may by law prescribe a. The circumstances under which and the class or classes of cases in which a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provisions of the subclause A of clause 4, subclause B. The maximum period for which any person may, in any class or classes of cases, be detained under any law providing for preventive detention, and subclause C. The procedure to be followed by an advisory board is in inquiry under subclause A of clause 4. So this was the Article 22 of the Constitution, which can be divided into two parts. First part deals with the case of ordinary law, that is, when a person is alleged to have committed an offense. Second part deals with the preventive detention law, that is, when a person is arrested on suspicion and under preventive detention. The first part of Article 22 guarantees four rights to a person who is arrested for an offense under an ordinary law. First guarantee is the first right is the right to be informed about the grounds of arrest. Second, the right to consult and to be defended by a legal practitioner of his own choice. Third, the right to be produced before a magistrate within 24 hours, excluding the journey time. Fourth, right to be released after 24 hours unless the judicial magistrate authorizes further detention. These safeguards are not available to an alien or to a person arrested or detained under a preventive detention law. As you can see, it is stated in Article 22, Clause 2 and 3. And these safeguards are not available to an alien or to a person arrested or detained under preventive detention law. The second part of Article 22 grants protection to the persons who are arrested or detained under the preventive detention law. It includes first, the detention of the person cannot exceed 3 months unless an advisory board reports sufficient cause for the extended detention. The advisory board is to consist of judges of the High Court. Second, the grounds of detention must be communicated to the detainee. However, the facts which are considered to be against public interest need not to be disclosed. Third, the detainee should be afforded an opportunity to make a representation against the detention order. These protections are available to both the citizen as well as aliens. Right to be informed the grounds of arrest in Joginder Kumar versus State of Uttar Pradesh, year 1994, the Supreme Court held that a detained person should know about his detention and is entitled to let any third person know the location of his detention. Right Article 22, Clause 2 does not apply in case of judicial custody. In Sadhvi Pragya Singh Thakur versus State of Maharashtra 2011, the Supreme Court held that the right under Article 22, Clause 2 is available only against detention by police and does not apply once a person is in judicial custody. Detaining persons under custody is permissible. Recently, the Supreme Court in Union of India versus Ashok Kumar Jalan 2019 pronounced that even if a person is in judicial custody, he can be detained under the relevant provisions of the concerned act. However, before detaining persons under judicial custody, there must be a proper application of mind and subjective satisfaction that there is a reason to believe that the detainee could be released on bail and that on being so released, the detainee will in all probability indulge in prejudicial activities. The same view, the same view has been earlier taken by the Supreme Court in another case, namely Union of India versus Dimple Happy Thakur in AIR 2019. So Article 22, as we all already stated, that the first part deals with the cases of ordinary law when a person is alleged to have committed an offense. Second part deals with the cases of preventive detention law when a person is arrested on suspicion and under preventive detention. Thank you.